By the time I pulled into my driveway that evening, 3 dump trucks were already sitting behind my garage. For a few seconds, I honestly thought I had turned onto the wrong property. Then the first truck raised its bed. A wall of gray gravel came crashing down onto the strip of land I had owned for 8 years. The sound was violent enough to shake the windows. Another truck was waiting behind it. A skid steer was already pushing the first load flat, carving a wide construction lane straight through the grass I had maintained since I bought the place. I parked, grabbed my phone, and started recording. That was when I saw the orange survey stake lying in the dirt. It had been pulled out. The contractor running the neighboring development, Travis Cole, stood near the equipment like none of this was unusual. He had workers moving across my land, trucks dumping material, and heavy machinery grinding over my property as if I had somehow signed it over to him. I had not. I walked the edge of the gravel and realized it was worse than I first thought. The new lane was nearly 20 feet wide in places. It crossed the section behind my garage, crushed 2 shrubs I had planted years earlier, and buried part of a shallow drainage swale. I kept filming. Truck numbers, company logos, license plates, workers, equipment, the displaced survey marker, everything. Travis acted like the matter had already been decided. According to him, this was temporary construction access for the housing project next door. The county had approved the job, the developer had deadlines, and I was standing in the way of a multi-million-dollar project. But there was one problem. I had never granted anyone access to that land. No easement, no agreement, no permission, and I knew exactly where my property line was supposed to be. I did not touch the equipment, I did not block the trucks, I did not threaten anyone. I just kept recording. What Travis did not know was that his crew had picked the worst possible strip of land to turn into a shortcut. Because less than a week later, a county inspector would be standing on that same gravel with an approved site plan in his hands. And by the end of that inspection, the machinery would stop, the trucks would turn around, and a bright red stop work order would appear at the entrance to the job site. The gravel was only the beginning. The real problem was hidden in the permit records. I had owned that house for 8 years, and until the development started next door, the biggest problem I ever had with the property was a broken sprinkler line. I bought the place after my divorce, at a point in my life when I wanted something simple and permanent. I was 46, working maintenance for a regional electrical contractor, and most days I came home tired enough that silence felt like a luxury. The house was not impressive. It was a modest 2-story place on the edge of a growing North Carolina suburb, with an attached garage, a long driveway, and just under 2 acres of land stretching behind it. But it was mine. That mattered more to me than square footage or resale value. I had put nearly every dollar I saved into the down payment, repairs, and improvements. I replaced part of the roof myself, rebuilt the back steps, planted shrubs along the garage, and spent years clearing brush from the rear section of the property. That back strip was the part I cared about most. It was narrow near the house, then widened farther back before meeting a wooded parcel that had sat undeveloped for years. Because of the odd shape, someone looking at it from a distance could easily mistake part of it for a service lane. But there had never been a road there. There had never been public access there, and there had never been an easement running through it. When I bought the house, I had paid for a boundary survey because the property lines were irregular. The surveyor placed markers at the corners and gave me a stamped copy showing exactly where my parcel ended. I kept that survey in a folder with my deed, closing documents, tax records, and insurance papers. At the time, I never imagined those papers would become more important than the house keys. My long-term plan was to build a small workshop behind the garage. Nothing elaborate, just enough space for tools, a workbench, storage, and maybe a place to restore an old pickup someday when work stopped taking up most of my life. That was why I maintained the land so carefully. Then the wooded parcel next door sold. A developer announced plans for a subdivision with more than 30 new homes. Survey crews appeared first, then orange fencing, then excavators, graders, portable toilets, concrete trucks, and the constant sound of diesel engines from sunrise to late afternoon. I never objected to the development. The land was not mine, and I understood the area was changing. For the first few weeks, the crews stayed on their side. Then I started noticing workers crossing the back corner of my property on foot. A few days later, pickup trucks began cutting through. At first, I assumed someone had made a mistake. I sent a polite email to the construction company explaining that the strip behind my garage was private property and asking them to keep their vehicles inside the development boundary. The response was vague. The contractor described the area as an existing construction access and suggested their team was operating according to the project plan. That bothered me because no one had ever asked me for access. Still, I did not want a feud with a contractor working next door for the next year. I took photographs, saved the email, and watched. The pickups became more frequent. Then a skid steer crossed. Then a small loader. The grass began turning into two parallel dirt tracks. That was when I started wondering whether this was still an honest mistake. If you have ever owned property next to a construction project, an HOA common area, or a neighbor who suddenly started treating your boundary like a suggestion, you already know how quickly something small can turn into something much bigger. Leave a comment with what you would have done at that point, because I was still trying to solve the problem quietly. I did not call a lawyer. I did not put up barricades. I did not start yelling at workers. I simply emailed the contractor again and reminded them that I had a recorded deed and a professional survey. That second message received no meaningful response. 3 mornings later, I noticed one of my orange boundary stakes had disappeared. I replaced it. 2 days after that, it was gone again. By then, I had started aiming one of my security cameras toward the rear property line. I still hoped I was being overly cautious. Then I came home and saw those 3 dump trucks behind my garage, and the moment the first load of gravel hit the ground, I understood something I should have realized much sooner. They had not misunderstood where my property line was. They had decided it did not matter. The next morning, the gravel road was longer. That told me everything I needed to know. Nobody had paused the work overnight to check whether I was right. Nobody had called me to discuss the property line. Nobody had sent a surveyor. Instead, another dump truck had arrived before 7, and Travis's crew had pushed the gravel farther across the rear section of my property. By the time I walked outside with my coffee, the strip behind my garage looked less like a yard and more like an industrial access road. The grass was gone beneath several inches of crushed stone. My 2 shrubs had been flattened. The shallow drainage swale running along the rear corner was disappearing under compacted gravel, and heavy tire tracks now crossed the exact area where I had planned to build my workshop. I took more pictures before I approached anyone. Travis was standing beside a pickup near the edge of the development, looking at plans on a tablet. I showed him the survey copy on my phone and pointed out that the gravel extended well inside my parcel. He barely looked at it. Instead, he pulled up his own site drawing. There was a dashed line near the edge of the development labeled as temporary construction access. That was what he relied on. From the small screen, the line appeared close enough to my boundary that someone unfamiliar with the property might assume it ran through the same area. But close enough was not the same as legal. I knew my land. I knew where the corner markers had been, and I knew that no developer, contractor, HOA, county employee, or private company had ever paid me for an easement or asked me to sign an access agreement. Travis treated that distinction like an inconvenience. The project, in his view, was already approved. The developer had schedules to maintain. Concrete deliveries were coming. Framing crews were waiting. Every lost day cost money. I was simply the homeowner standing beside the fastest route into the construction site. That arrogance bothered me more than the gravel. It was the assumption that because his project was larger than my property, his rights must somehow be larger too. I went back inside and sent another written notice to both the contractor and the developer. I attached my survey. I included photographs. I stated that I had not granted access, and that construction vehicles were crossing private property without permission. Then I waited. The next truck arrived less than 2 hours later. That was the moment I stopped believing this could be solved through a polite misunderstanding. Over the following day, the situation escalated. Workers continued driving over the strip. A skid steer widened the gravel lane near the back corner. A loader pushed material toward the drainage swale. I placed several bright marker stakes along the boundary as a temporary visual warning. The following morning, 2 of them were missing. I replaced them again. Then I checked the security camera I had repositioned toward the rear property. The footage showed one of the construction workers walking directly to the stakes, pulling them out, and carrying them toward the job site. I saved the clip immediately. That afternoon, I called the sheriff's office using the non-emergency number. A deputy came out, walked the area, looked at the gravel, and reviewed the documents I had with me. But because the dispute involved a boundary claim and neither side had a surveyor physically marking the line at that moment, he treated it as a civil property matter. He advised me to document everything and obtain current professional confirmation of the boundary. That was reasonable. But Travis apparently interpreted the deputy leaving without stopping the project as permission to continue. The next morning, construction traffic increased. Then I received an email from the contractor's office that changed my entire attitude toward the situation. Instead of addressing my ownership documents, the message warned me not to interfere with vehicles or equipment, because doing so could create a safety issue and disrupt an active construction site. I read it twice. They had entered my property, they had dumped gravel on it, their workers had removed my markers, and now they were creating a written record suggesting that I could become the problem if I interfered. That email turned out to be one of the best things they could have sent me. Because from that point forward, I stopped trying to convince Travis of anything. I did not place a vehicle across the gravel. I did not move their materials. I did not damage equipment. I did not give them a single photograph they could use to make me look unreasonable. I simply documented every truck, every tire track, every load of gravel, every email, every missing marker, every new foot of damage. By the end of the second day, I had a folder on my computer containing dozens of photographs and multiple camera clips. But there was one thing I still did not have: the actual county-approved site plan. Travis had shown me a drawing on a tablet, but I had never seen the official document stored in the county records. That difference started bothering me, because if his drawing really authorized that access, there should have been a permit record connected to it. And if it did not, then Travis had just spent several days creating evidence against himself. The next morning, before I went to work, I opened the county permit portal. What I found there made the gravel road look like the smallest problem on that construction site. I started with the permit portal because it was the one place Travis could not control. The county website was not pretty. It looked like it had been designed 15 years earlier and never updated. But the records were there if you knew what to look for. I searched the subdivision by address first, then by parcel number, then by the developer's company name. Within an hour, I had downloaded the grading permit, the approved site plan, erosion control documents, inspection notes, and several revised drawings that had been uploaded during the approval process. I created a new folder and saved every file with the date in the file name. Then I opened the site plans side by side. That was where the first inconsistency appeared. One older drawing showed a dashed access route near the western edge of the project, close to my land. But the final approved plan did not. The construction entrance on the approved version was on the east side, connected to the public road. I zoomed in until the parcel lines were visible. My property was outside the development boundary, completely outside. I checked the legend. I checked the revision date. I checked the approval stamp. Then I checked again because I wanted to be absolutely certain I was not seeing what I wanted to see. The result never changed. The road behind my garage was not part of the approved construction access. That alone was enough to make me suspicious, but I still needed professional confirmation of the property line. I called the surveying company that had handled my original boundary survey 8 years earlier. They still had the old file. 2 days later, a licensed surveyor came to the property with GPS equipment, a metal detector, and copies of the recorded plat. I stayed out of his way. I did not tell him where I believed the line should be. I wanted an independent answer. He located one monument near the rear corner beneath several inches of soil. Another marker was still in place farther south. Using those control points, he re-established the boundary. Then he placed fresh stakes along the line. The gravel crossed it almost immediately. At the narrowest point, the construction lane was more than 11 feet inside my property. Near the rear corner, it was closer to 18. I photographed every stake with the gravel visible behind it. I also asked the surveyor to prepare a signed sketch showing the encroachment. That document cost me money, but it gave me something more valuable than an argument. It gave me measurements. While he worked, he noticed something else. The orange wooden stake I had originally seen lying near the gravel was not a legal monument. It had only marked the survey line above ground. The actual corner pin was still buried where it had always been. That mattered, because anyone claiming the boundary was unclear now had a much harder story to tell. The metal pin had not moved. The property had not changed. Only the construction activity had. That evening, I went through my security footage again. I made copies of the clips showing trucks crossing the line. I saved the video of the worker removing my temporary stakes. I captured still images showing dates and timestamps. Then I created a simple timeline. The first email I sent, the first pickup truck, the first missing marker, the first dump truck, the deputy's visit, the contractor's warning email, the survey, the permit records. I was not preparing to win an argument anymore. I was preparing to prove a pattern. The next step was the county GIS system. I pulled the tax map for my parcel and compared it to the subdivision parcel. The online map was not accurate enough to establish a legal boundary by itself, but it confirmed the basic shape shown on my deed and survey. More importantly, there was no recorded access corridor connecting the subdivision through my land. That sent me to the county register of deeds. I searched for easements under my parcel number. Nothing. I searched the previous owner. Nothing. I searched the developer. Still nothing. There was no recorded right-of-way, no temporary construction easement, no access agreement, no document giving Travis or the developer any legal right to cross that strip. Then I went back to the grading permit. One condition caught my attention. Construction traffic was supposed to use the designated entrance shown on the approved plan, and the contractor was required to maintain the approved erosion control measures during grading activity. I looked outside at the gravel. Part of the drainage swale behind my garage was buried. That was no longer just a property line problem. If the swale was connected to the approved drainage pattern, the contractor might have altered runoff without approval. I did not want to guess. So I called the county planning office. I kept the question simple. I gave them the permit number, identified my parcel, and asked whether the approved project documents authorized a temporary construction access across private property outside the development boundary. The staff member pulled up the same final plan I had downloaded. The answer was no. I followed with one more question. Had the county received any revised plan approving access through my parcel? Again, no. I wrote down the name of the employee, the date, the time, and the permit number. Then I sent a short follow-up email asking for written confirmation of what we had discussed. The next morning, the reply arrived. I printed it. By then, the evidence on my kitchen table had become a stack: deed, survey, signed encroachment sketch, site plan, permit conditions, security footage, photographs, emails, county confirmation, and for the first time since the gravel trucks arrived, I stopped feeling like I was reacting to someone else's decisions. I finally knew exactly what Travis had done. What I did not know yet was how much trouble that unauthorized road was going to cause him. Because when I sent the survey and permit documents to the county, another department noticed something I had completely missed. The department that called me back was erosion control. I had expected the county to care about the property line. I had not expected them to care about the gravel itself. The inspector who reviewed my photographs asked me to send wider shots of the rear corner, especially the section where the new access lane crossed the shallow drainage swale. I sent everything I had. Within an hour, he called again. The approved erosion control plan showed that swale remaining open. It was part of the drainage pattern designed to move runoff away from the neighboring construction area. Travis's crew had pushed crushed stone directly across it. That meant the problem was no longer limited to unauthorized access over private property. The contractor had changed a drainage feature associated with an active grading permit, without approval. I opened the permit packet again and found the condition the inspector was referring to. The designated construction entrance was clearly marked on the east side of the subdivision. The erosion control measures were shown separately. Nothing in the approved documents allowed a second access road behind my garage. Nothing authorized gravel over the swale. Nothing connected my parcel to the project. The more I looked, the worse it became for Travis. I sent the county my new survey showing exactly how far the gravel crossed my property line. The response came back almost immediately. My parcel was outside the development boundary. There was no county-approved construction access through it. There was no temporary right-of-way. There was no permit revision giving the contractor permission to use it. The official records matched my deed. That was the legal turn I had been waiting for. Travis had spent days acting as though county approval gave him authority over anything convenient to the job site. But permits did not create ownership rights. A grading permit did not create an easement. A site plan did not allow a contractor to take private land simply because it made truck access easier. And even if the county had shown an access route on a preliminary drawing, that would not have replaced the need for permission from the actual property owner. I wanted someone who understood property law to review everything before I took another step, so I contacted a local attorney who handled land use and boundary disputes. I brought him the entire file, the deed, the old survey, the new survey, the signed encroachment sketch, the permit records, the approved site plan, the preliminary drawing Travis had apparently relied on, the contractor's emails, the county confirmation, and the camera footage showing a worker removing my temporary stakes. My attorney spent most of the meeting quietly reading. Then he organized the documents into 3 separate issues. The first was trespass. The contractor had repeatedly entered and used land that did not belong to the development. The second was physical damage. They had placed material on my property, destroyed vegetation, compacted soil, and altered part of the drainage area. The third was the permit problem. The contractor appeared to be operating outside the approved construction plan and interfering with an erosion control feature. That third issue mattered because it gave the county a reason to act independently of any lawsuit I might file. I did not have to convince Travis to respect my property. I only had to provide the proper agencies with accurate evidence. My attorney prepared a formal demand letter. It required the contractor and developer to stop using my land immediately, cease all construction traffic across the parcel, preserve all records related to the access route, and arrange restoration of the damaged area. It also demanded that they identify any easement, recorded agreement, permit, or other legal document they believed authorized their use of my property. That last request was deliberate. If they had legal authority, they could produce it. If they did not, there was nowhere left to hide. The response came from an attorney representing the developer, not Travis. That distinction caught my attention. The developer claimed it had been told the temporary access had already been cleared for use by the contractor. My lawyer asked for the document proving that. There was none. No easement agreement, no temporary license, no payment record, no signature from me, no recorded instrument at the Register of Deeds. Nothing. Then an email chain surfaced. The developer had asked Travis earlier in the project whether access issues along the western side had been resolved. His response indicated that access had been handled. That single phrase became very important, because there was no evidence he had ever contacted me before sending it. The developer had apparently relied on his representation. I had assumed Travis was acting arrogantly because he thought the developer would protect him. Now it looked like the developer had been operating under information Travis himself had supplied. His position began collapsing from both directions. The county wanted to know why construction traffic was using an unapproved route. The developer wanted to know why Travis had represented the access as settled. My attorney wanted proof of a property right Travis did not have, and I had video showing his crew continuing after receiving written notice that the land was mine. Travis tried one final argument. According to the response relayed through his company, the route had been used as an informal access path during early site work, and the contractor believed that continued use was implied by necessity and established practice. My attorney rejected that immediately. The subdivision already had an approved construction entrance. This was not a landlocked parcel. There was no necessity, and driving across someone's property for a few weeks did not magically create a recorded easement. Convenience was not ownership. Repetition was not permission. Confidence was not legal authority. Then the county added the piece that finally destroyed Travis's position. A planning employee located the preliminary drawing that contained the dashed route he had shown me. It had been superseded before final approval. The final stamped site plan removed that route and directed construction access elsewhere. Travis had been pointing to an outdated drawing the entire time. I stared at the final plan on my computer and realized how close I had come to accepting his version simply because he had spoken with certainty. He had equipment, he had workers, he had a multi-million-dollar project behind him. I had a modest house, a survey folder, and a camera. But the county records did not care who looked more powerful. The line on the approved plan was clear. The line on my survey was clear. And the line Travis had crossed was now impossible to explain away. The following morning, I received notice that county staff would conduct an on-site inspection. They wanted the approved site plan available. They wanted the survey stakes visible, and they wanted the contractor present. For the first time since the first dump truck entered my property, Travis was not going to be the person deciding what the rules meant. The county was. The county inspection started just after 9 in the morning. By then, I had already placed copies of my survey, the approved site plan, the permit conditions, and the signed encroachment sketch on the hood of my truck. The county inspector arrived first. An erosion control officer pulled in a few minutes later. Then Travis showed up. He looked different without machines moving behind him. For weeks, he had always seemed to have noise, equipment, workers, and schedules backing him up. That morning, all he had was a rolled set of plans under his arm. The inspector began at the subdivision entrance. He checked the approved construction access shown on the stamped plan. Then he walked toward my property. No one argued. No one needed to. The new survey stakes made the boundary visible. The gravel crossed them. The inspector measured several points and compared them to the plan. He asked Travis for the approved revision authorizing the western access. Travis could not produce one. He showed the older drawing again. The inspector looked at the revision block and immediately identified it as superseded. That was the moment the entire situation changed. For the first time, Travis was no longer explaining the rules to me. He was answering questions. The erosion control officer focused on the drainage swale. He photographed the compacted gravel, checked elevations against the approved plan, and documented where material had been pushed into the drainage path. He made it clear that restoring the swale would not be optional. Then the county staff walked deeper into the job site. I stayed near my property line. I did not follow them around. I did not need to. About 20 minutes later, the inspector returned and told me the contractor was being directed to stop using my parcel immediately. No construction traffic, no equipment, no deliveries, no temporary access, nothing. The western route was not approved. The county also required corrective work on the drainage area and documentation showing how the contractor planned to restore compliance. That alone would have been enough for me. But the inspection did not stop there, because once county staff began comparing actual site conditions with the approved grading documents, they found additional inconsistencies around the access area. The inspector called Travis and the site superintendent together. A formal notice was prepared. Then a bright red stop work order was posted for the affected grading and access operations until the violations could be corrected and the county was satisfied that future construction traffic would follow the approved plan. The change was immediate. A loader that had been operating near the rear section shut down. A dump truck approaching the site was redirected. Workers who had been preparing another load of gravel stopped. The lane behind my garage went quiet for the first time in days. I stood there looking at the same gravel Travis had treated as proof that the decision had already been made. Now it was evidence. The developer's representative arrived before noon. He spent most of his time with the county staff and barely looked in my direction. Later, my attorney told me why. The developer had started reviewing its internal correspondence. They found the earlier message where Travis had represented that the access issue was handled. They also found no agreement with me, no signed permission, no easement, no payment, no legal document of any kind. The problem had stopped being a disagreement between a contractor and a homeowner. It had become a contract problem between Travis and the developer, a permit problem between the contractor and the county, and a trespass claim between the contractor and me. Those were three different pressures hitting at the same time. The developer's attorney contacted mine that afternoon. The tone was completely different from the earlier emails. There were no warnings about me disrupting construction. No claims that the access was already approved. No suggestion that I was creating a safety issue. Now they wanted documentation of damages. They wanted photographs. They wanted the survey invoice. They wanted estimates for removing the gravel and repairing the drainage area. I sent everything through my attorney. The county also required a corrective plan before the affected work could resume. The contractor had to show where trucks would enter legally. The drainage swale had to be restored. The material placed on my property had to be addressed. And future work had to match the approved site documents. For several days, the western side of the project remained quiet. Every morning I would look out behind my garage and see the machines sitting on the other side of my survey stakes. Nobody crossed them. Nobody removed them. Nobody told me they were only temporary. Those wooden stakes had not become stronger. The law behind them had simply become visible. Then my attorney called with the news I had not expected. The developer was considering removing Travis's company from the project entirely. The unauthorized access had caused delays. County review had created additional costs. The drainage correction would require new work. And the developer now believed it had relied on inaccurate information about property access. The multi-million-dollar project Travis had used to intimidate me was now the very thing putting pressure on him. The larger the project was, the more expensive his mistake had become. A few days later, county vehicles returned for a follow-up inspection. This time, Travis was not there. A different site manager met them at the entrance. That was when I realized the fight was effectively over. What remained was not about whether they had the right to use my land. That question had already been answered. Now it was about who was going to pay to put everything back. The settlement came together faster than I expected. The developer had no interest in dragging the dispute into court, especially after the county records, survey, camera footage, and permit documents all pointed in the same direction. Their attorney agreed that the gravel had to be removed from my property, not pushed aside. Not covered with dirt, removed. A different contractor came in under county oversight and hauled the material away. The compacted area was loosened, fresh topsoil was brought in, and the damaged section behind my garage was graded and reseeded. The drainage swale was reopened and restored to the condition shown on the approved plan. The 2 shrubs were gone for good, but their replacement cost was included in the settlement. So were my survey expenses. My attorney fees were covered under the agreement. The developer also paid for the restoration work, rather than leaving me to chase Travis's company for months. Then came the consequence Travis had probably feared most. His company was removed from the project. The developer never gave me every detail of that decision, but my attorney confirmed that the unauthorized access, the permit violations, the delays, and the inaccurate representation about property rights had damaged their relationship beyond repair. The project continued. Just not with him. A new contractor took over, and every construction vehicle used the approved entrance on the east side exactly where the county plans said it should. Nobody crossed my property again. Nobody touched my survey stakes. Nobody sent me another warning about interfering with construction. A few months later, the grass behind my garage had mostly grown back. I installed a low boundary fence along the most vulnerable section and kept the new survey with my deed in a fireproof document box. I also kept the footage, not because I expected another fight, because the whole experience taught me how quickly someone else's confidence can make you question your own rights. Travis never had more legal authority than I did. He only had bigger machines, more workers, and a louder sense of certainty. For several days, that was almost enough. What stopped him was not anger. It was documentation, a camera, a survey, a deed, permit records, county files, and the decision to keep collecting facts instead of giving him the confrontation he seemed ready for. That was the part I remembered most after everything was over. Property rights do not protect themselves. Sometimes you have to prove where the line is, prove what was approved, and prove what happened after someone crossed it. If this story made you think differently about surveys, permits, or construction access, leave a comment with how you would have handled it. Share this with someone who owns property near a development or HOA. Save it in case you ever need to remember what evidence matters. and subscribe for more stories about property rights, legal boundaries, and what happens when someone learns too late that convenience is not permission.